Thanks for joining us today. It's been a while since we've addressed our supporters and donors, but we have some important news, some updates to one of the cases in particular today we want to discuss. And today I've got with me Karen Osborne and Emily Ling, both attorneys for Silent Majority Foundation. And today we're discussing a case they've been working on kind of relentlessly, tirelessly for last several months on behalf of La Center School District. It's something that we have all, taken personally, each of us with children of our own and grandchildren also. We know just how important parental rights are to us and how they're being infringed upon. And step by step, the state is trying to eliminate us from the decisions that are being made on behalf of our children. So we're going to get into what's going on with La Center School District and how that school district has stepped up and stood up for the rights of the parents in that area. I'm glad to have you guys here today. Karen, you want to kick us off with an update or maybe just a quick synopsis of the case?
Sure. And Emily, jump in anytime you see fit. So La Center School District has been in a fight with the Office of Superintendent of Public Instruction. In 2019, the Office of Superintendent of Public Instruction, OSPI, that's how I'm going to refer to them from now on, is created this model policy in regard to transgender students. And in this model policy included a prohibition on informing parents of a student's transgender status unless the student consented. La Center disagreed with that and chose to create in their model policy a parental notification requirement. But now, in the process of all of this, even prior to amending the model policy that was brought out, La Center had a pronoun directive in which they said teachers should not proactively ask students their pronouns, particularly not in front of other people. Now, La Center got complaints about both of these things, particularly the pronoun directive from a teacher, and a variety of other teachers signed this complaint. And since then, La Center has been fighting OSPI as regards both the pronoun directive and the parental notification issue. Is there anything you'd like to add, Emily?
No, I think that's good so far.
Okay.
So just where we've been in the case right now is OSPI conducted an investigation, sent out a findings letter to La Center School District, and that was early last year. And the district has appealed that. So we've been in the administrative court preparing for a hearing. Ultimately, it's preparing for a hearing due to this appeal. So that's where we've been in since we've taken up the case.
Okay. So what exactly is OSPI claiming against the school district? And what is it the school district wants to ultimately happen with this?
You want to take that, Emily?
Sure. So the OSPI in their findings letter found that the school district treated gender expansive students differently in their pronoun directive and in not allowing staff to ask publicly or privately their pronouns. And then they found that their model policy did not follow the law that requires school districts to create a model policy for their school. And the core reason that they're saying it doesn't comply with the law is because they created a collaborative family protocol where parents are involved almost from the start. If a student comes and says, I'm changing my gender identity, I want to change my name and pronouns, La Center includes the parents. So everything that OSPI charges revolves around that, and they are saying in many different ways that this discriminates against these students. They center it on the ability of the transgender or gender expansive student to prevent the parents from knowing that they have a right to prevent that. And so that's what we've centered on. Do they have the ability to do that? And what is at the core is that due to parental rights, constitutional parental rights, they don't have the right to keep this information from parents. So that's where we've been.
Absolutely.
Right. So what OSPI is essentially saying is that the students have a right to privacy against their parents. There has never been a law in any format that allows a child to keep a secret from their parents while they're minors. Of course, it all changes, of course, when a child becomes an adult. But as a minor, the child has never had the right to keep secrets from parents because it's essential that parents understand what's going on in a child's life. We understand and have always understood as a society that parents need to be able to guide their children. And if the parents don't know what's going on with their children, they cannot guide them. We have also understood that children do not have the capacity or the understanding to make these decisions on their own. They just don't have the experience, the knowledge, or the
Wisdom.
frankly,
The wisdom.
the wisdom to do it. Correct. So OSPI in its directive has decided otherwise, contrary to all of human history, as far as I can tell. So that's kind of what's going on.
So I think you've described this in a way that flips what's going on its head as far as how it's been described in the courts or in public conversation. When you talk about the school trying to become the agent of the child instead of the agent of the parent, is that how you describe that, Karen? How would you fully describe what we're seeing here?
So yeah, that would be one way I would describe it and have described it in the past. Schools really are there because parents allow them some authority over their children during the school day to teach them, right? And so schools are allowed and teachers are allowed to exercise the authority needed to give them an education. But in the process of doing that, schools are also required to keep parents informed as to what's going on. And that's because parents ultimately have the decision-making power and the authority over their children. This authority that schools have is purely an authority given to them by the parents. It is a derivative authority. It is not a direct authority. That's why I say that schools are really the agents of the parents. OSPI wants to make schools the agents of the student by saying that the students have to consent to what parents know, at least as far as, as far as it goes with the gender identity. And this is a very, very dangerous thing to start. It's a very slippery slope. And we really don't want to go down that road.
Right. Right. Now,
So-
obviously, this is directed from the state, so these other school districts are subject to the same rules that OSBI has put into place. But La Center stands alone in really challenging this, and has for the last. It's been 3 years that they've been in the middle of this dispute.
Mhm.
What are some of the I know we've done some discovery, and there's been some records that we've requested. What was I think there were some records that you requested that were quite enlightening of the way that the state has taken a position on this.
Yeah, so one of the emails that we have received stated that La Center School District is OSPI's test case when it comes to these issues. And I think that a big reason why they chose the Center School District is because the Center School District has stood so firmly on parental rights. And so they wanted to make an example of the center in order to bring all of these other school districts into line. Well, that changed this week. And we are just so excited that that is the case.
So
and-
so what happened this week? We've put a little bit out on social media about it, but I think that the reason we're all talking about this right now is because it is an exciting thing. What came down this week that essentially changes the position that we have now against the state?
Yeah, so there's been a case out of Southern California. It's been going through the courts now for several years. I don't even know exactly when it started. But it was appealed to the Ninth Circuit, and it's called Mirabelli v. Taylor. No, forgive me.
Is it Bon?
Bonta.
Is it
Mahmoud
Bonta?
v. Taylor, but Mirabelli v. Bonta.
Right.
And I was getting two cases. I was combining two cases, so forgive me. But Mirabelli v. Bonta. And in the district court, at the trial court level, the judge granted an injunction against the state and said that California could not keep gender identity issues from the parents, regardless of student consent. So, and when the state then appealed to the Ninth Circuit, the Ninth Circuit overturned that injunction and what's called stayed that injunction and said, no, that injunction cannot stand while this case is being appealed. So then the parents immediately appealed the case to the Supreme Court. It's called an interlocutory appeal, which means that they're appealing an issue before the case is final, which is not typically the way it's done, but there are some issues that can be appealed prior to the final decision of the case at that court level. And this is one of those issues. This week, the Supreme Court took up that interlocutory appeal and issued a per curiam opinion saying that they were lifting the stay and the injunction would hold all the way through the appeals process. So the state of California is no longer allowed to enforce a very similar law to the one that OSPI is enforcing. This is significant because OSPI has now decided that they need a 60-day continuance on our case in order to evaluate how this Supreme Court decision affects our case. Clearly, they understand that it is directly contrary to the stance they have been taking.
Mm-hmm. Is there anything specific that you see from their previous stance now that would be directly, and contrary to the per curiam given by the Supreme Court?
Yeah, so the facts of the California case are deal mostly with the idea that parents can't be told about gender issues without the student's consent. That's the primary issue in the California case. Now, there are two parents in that case were suing based on two separate grounds. One was religious grounds, free exercise grounds, and the other one was substantive due process grounds. So under substantive due process, a parent doesn't have to have a religious belief in order to bring the suit. But under the free exercise, the parents do have to have a religious belief against what the school is doing. In that case, on behalf of those parents, the religious parents, the court stated that the recent Supreme Court case that they decided, Mahmoud v. Taylor, applied here, unlike what the Ninth Circuit said, that it was a much broader the Ninth Circuit, along with the Sixth Circuit, was trying to apply Mahmoud v. Taylor in very narrow circumstances of that particular case. And the court said, no, you are misunderstanding our ruling. In fact, the court said it is so significant that they said this: indeed, the intrusion on parents' free exercise rights here, unconsented facilitation of a child's gender transition, is greater than the introduction of LGBTQ storybooks we considered sufficient to trigger strict scrutiny in Mahmoud. So what they're saying is that this is even a greater intrusion into the religious beliefs of parents than they found to be in Mahmoud.
Wow.
So that requires the state then to prove that they have a compelling interest and that they are narrowly tailoring the law to deal with that compelling interest. The Supreme Court has said they have neither. The compelling interest that the state claims is student safety and privacy. But what the state failed to take into account is that the parents are the primary protectors of the children's best interests. So that is not a compelling interest as against parents in this case. But they also said that prohibiting parents from knowing about gender identity was not narrowly tailored. And the reason it wasn't narrowly tailored is because they were prohibiting all parents from hearing about students' gender identity if the student didn't consent to it. And what they were saying is that, well, you could narrowly tailor it is if you only included abusive parents, right? If you could show that the parents were abusive, then you wouldn't have to tell them. But otherwise, parents need to be involved.
Right.
This is very much like our case. Wouldn't you agree, Emily? You want to take it from there?
Yeah, what I would say how this directly affects our case and OSPI's what OSPI has been requesting or requiring is that the OSPI, in trying to prevent this information from getting to parents, but kept running up against this issue that parents have the right to see their child's education record if they request it. And this is under the federal FERPA law, that they have a right to see their child's education record. So in revisions that were made to this policy, the model policy in 2022, they started kind of moving their tactic to, okay, yes, parents can request this information in an education record and they can get it that way, but there is no proactive duty by the schools to provide this information. And that's what they've been standing by, is there's no proactive duty. What this Supreme Court decision shows is, of course, there is a proactive duty for schools to let parents know significant issues that are going on with their child. And that is under parents' constitutional rights to know this information. So I would say one of the big issues that OSPI is having now is this decision is going to override their statements of there's no proactive duty to do this, because of course there is. So I'm sure this is being evaluated.
So they've asked for 60 days to figure out how to get around that.
Yes.
If they can, which, you know, they are pretty crafty in the way that they take an argument and flip it on its head and try and change what the judge was actually trying to accomplish. But we have hope. So my next question is, as a parent myself, my 6 daughters, 2 of which are in the school system here in Washington, what does this mean for me as a parent? What should I expect from the school district at this point?
Well, so I wanted to go on to so under the due process grounds, which doesn't mean that you have to be religious to make these claims. Under the due process grounds, all parents can make these claims, and there is a proactive duty for all parents, right, to actually understand their students' gender identity issues. Now, what can you expect from school districts? I can only say what I would advise school districts to do. Because this case makes clear that a parent could easily sue a school district under 1983 and based on either their religious rights or their 14th Amendment substantive due process rights, that I would be very, very reticent to follow the OSPI guidelines because you are setting yourself up for a lawsuit. And you never know exactly which student and which set of parents are going to run into a lot of issues that are going to create a lawsuit. And under 1983, you will be personally liable. That is what I would advise. Now, whether or not their lawyers are going to advise that, I don't know. And whether or not they are going to react that way, I don't know. But they really need to think long and hard before they continue to violate parental rights.
Right. So between the two of you, what is our next step? And maybe we don't want to give our strategy away, but what are we looking at to get ready for this and the expectation of our next step as a foundation?
Well, I think in terms of the case, we just have to wait and see what steps the state takes, right? And then react from there, because it's quite possible they'll dismiss, but we don't know exactly what they're going to do. Whether they're going to dismiss, whether they're going to narrow it, we don't know. So we will have to wait and see.
Right.
In terms of the foundation, well, we're always open to helping anyone who needs help with their parental rights.
Right.
I'll just throw that out there.
So one thing you mentioned, Emily, was that parents have the right to get that record. Is that something that you recommend these parents start thinking about if they're seeing any kind of behavioral issues or noticing any difference in their children?
Yes, and personally, if I had a child in public school, I would make a practice of requesting their record. Maybe once a year, if you feel that changes are happening in your child or you're noticing something that you don't understand really what's going on and they're not telling you, you can always request the record and the school must provide it to you. One thing that we've heard from other people looking into this, and we understand and don't have concrete evidence, but that the schools aren't always putting this information, the staff are not always putting this information into the education record. So we just, as parents, stay vigilant, pay attention to your children. If they're changing in some way or acting differently, inquire, go to the school, try to find out what's going on. That's what I would suggest.
Perfect.
Yeah, and ask very specific questions. You have the right to ask the teachers and the principal very specific questions about what's going on with their students and what they are doing in the classroom, what the teacher is doing in the classroom. Is the teacher asking for pronouns? Is the teacher, teaching gender topics? Are they reading books that have different genders in them? What are they doing? You have the right to know.
Perfect. Anything else that you want to bring up about the case or anything to closing remarks?
I think Emily summed it up pretty well. But we will be continuing to monitor what OSPI does and whether or not they begin to revamp their model policy. That'll be very interesting to see what they do going forward.
Very good. Well, on behalf of parents across Washington State, I thank both of you for the work and the tireless work you've been doing on this. Understanding that, the center being single and standing up to this as a school district, there are a lot of parents that I've talked to that are really concerned about the way that not only the education system is going, but the ideologies that are being pushed along in this state. And so, thank you very much for the work that you're doing there. And for those that have listened along, the thing that you can do, the call to action for you is not only just be vigilant and check on your kids and pull that record from the school and see what's going on if you notice anything's going on. But also you can donate and help us continue to stand for parental rights, because we can hope that things will change, but we know that this is a long-term battle, and there's years that have gone into the state making these policies and changes. It's going to take years for us to reverse course, and it's going to take all of us being vigilant and working toward the cause of protecting our children from those that would teach them or hurt them or harm them in these ways. So thanks for listening along. Go
So
ahead,
the
Karen.
only other thing I'd like to add is that I just want to shout out to the superintendent of La Center. He has been just a lion when it comes to this. He has not backed down because he knew that this was the right thing to do to involve the parents. And indeed, it was the right thing to do. And a shout out to him because he has helped to protect all parents' rights in Washington. So
you remind me, did you want to read anything from that letter that he wrote, or did you want to share that at this point?
I think I will. So for more than he wrote a letter, this will be on their website, I believe, but for more than 3.5 years, our district has remained steady in one conviction. Schools serve students best when they work in partnership with families. Parents are the primary decision makers of their children's lives, and they deserve to be included in significant matters affecting their children's development and well-being. Our position has never changed. We believe schools should support the students while respecting the role of families who know and love their children best. Strong schools and strong families are not in conflict. They are partners in the responsibility of educating their children. And I can attest to the fact that that has been their stance all along. They have not changed their stance one bit.
And that superintendent is Peter Rosenkrantz from
Yes.
LCSD. Yeah. So shout out to Peter.
Mm-hmm.
Well, thank you, Peter Rosenkrantz, for being willing to stand up for parents across the state of Washington. And, if we get a good ruling here and turn the tides here, probably will have effect in other states and other places as well, where parents are worried about what's going on in the education system. Well, thank you for listening along. And if you have any questions, you can direct them to info@silentmajorityfoundation.org, and donations there as well. We appreciate the support and thank you. And remember, we may be the silent majority, but we cannot be silent anymore. Thank you.
Thank you.
Thank you.